Dr. Chris Rapoff of QME Continuing Education. Welcome to this week's presentation. Earlier this year, the California Division of Workers' Compensation, the DWC, implemented some very important changes to the reappointment regulations addressing the process of reappointing the qualified medical evaluators in the state of California. This is known as Title 8 CCR, Section 50, and specifically Part G. Now, today I'll explore the major DWC regulation changes and what it means for you as a QME in your very next reappointment process. First, these are the following sources that I reference when producing this presentation. Feel free to copy and paste these links into your browser if you would like to read more about these changes to the QME reappointment process. In addition, last year I had the opportunity to interview a workers' compensation appeals board judge regarding the quality of QME reports. She gave me some very interesting information and a lot of insight as to what they look for when they qualify a report as substantial medical evidence. So you'll be very surprised and enlightened to hear what she had to say as well. This will be interspersed throughout this presentation. Providing a little bit of background, the QME reappointment regulations under this Title 8 CCR Section 50 took effect in July of 2020 and just recently were updated this year. There are many changes you must be aware of as you apply for reappointment as a QME in the DWC, as they try to ensure that the QMEs are qualified, competent, and ethical to perform medical evaluations for workers' compensation cases. Now, today we'll examine two of the major changes that recently were implemented. First, we have a change in the number of continuing education credit units required per reappointment for every 2 years. Now, the hours required for reappointment of all specialties will change from 12 hours to 16 hours, with the following requirements after April 1st of 2026, so we still have time. But if you traditionally complete all of your QME CEU requirements online, this will also be a change because 6 hours will be required to complete in person or an on-site lecture. 6 of the 16 will have to be in the seat, where the other 10 you can get online. Now, the second major change has been a long time in coming. First, let's see what the change encompasses and then spend some time explaining why the change was implemented. So, at the time of your reappointment, along with the reappointment application, the physician now must submit their 2 most recent medical legal reports in which there was a face-to-face evaluation and the injured worker was determined to have reached the status of maximum medical improvement or permanent and stationary, for the reappointments to be submitted on or after April 1st of this year, 2024. Now, if the QME did not generate 2 such reports in the 2 years prior to the reappointment date, you must submit a statement of explanation in lieu of these reports. Now, these 2 reports are going to be submitted through an online portal, which is also new. The DWC has launched a new online portal for the qualified medical evaluators to submit their medical legal reports as required by the recently approved regulations. Now, the link you see here on this new online portal appears in red for your convenience. For those of you that have been following my blog over the last couple of years, you'll know that I have been telling you that this was forthcoming. It was just a matter of time. But you may be asking, why are these report submissions really necessary? What's the purpose? What must we first discuss that when it comes to a QME report in a workers' compensation case, there were and are several potential complaints or issues that the workers' compensation judges encounter. And this was also brought out to pass when I spoke with the workers' compensation judges, as I told you before. So I'm going to divulge them over the next several slides as to what the concerns are and what these judges and attorneys are looking for a competent QME report. Okay, first, we're going to discuss some objectivity or lack of objectivity by the QME reporter. Judges do expect a QME's report to be impartial and based on objective medical evidence. Now, the complaints have arisen when the QME's report appears biased, influenced by an external factor like maybe pressure from the insurance company, a claims adjuster, or one of the attorneys. Number two, an inadequate explanation or rationale. How many times have you heard the how and the why? How I came to my conclusion and why I did. And here the judges rely on these reports to make informed decisions. And also, if a report lacks clear explanation for the conclusion, or you don't produce the why, or you fail to address a specific issue, or you lack a well supported rationale, the judges find this to be insufficient. Okay, I mentioned address specific issues. This is when you are required to address every question as posed by every attorney's cover letter or the claims adjuster in their cover letter. The judge that I spoke to brought this up as well, and it's discrepancies with other QME medical evidence. The judges do actually compare the QME reports with the other medical records provided and the treating physician's reports and other diagnostic tests. So they don't sit alone, they are actually scrutinized. Other inconsistencies or contradictions between the QME's findings and other evidence can raise concerns. So, for instance, if you have a report and in your examination findings you say one thing, but in your discussion section or your conclusions or your impressions, you say another. That is inconsistent. Also, they discuss timeliness and delays. Judges expect timely QME evaluations and reports. They stick to the 30-day rule. If you do go past 30 days, you're required to request an extension that has to be requested 5 days prior to your 30-day deadline, not the same day that you're supposed to have it installed or sent to them. And also, the delays in issued reports really can hinder the progression and frustrate the legal process, delaying the case even further. Another problem in our reports are that they realize that there's insufficient detail on the permanent disability rating. Now, we provide impermanent impairment. Permanent disability is determined by the raters in the DWC. However, the QME reports must provide a whole person impairment rating that actually would translate to a permanent disability rating. If the rating lacks specificity or doesn't adequately address the impact of the injured worker on the injured worker, the judges may question its validity. In addition, the failure to address all relevant issues. Judges look for a comprehensive evaluation, not an outline, but a comprehensive evaluation report. If a QME report overlooks critical aspects, say for instance of an injury, or fails to address the specific question posed by the parties, here we go again with answering all attorney questions. It can lead to some dissatisfaction and can actually determine that your report does not qualify as substantial medical evidence and it can be thrown out. I touched on this briefly earlier, but they look for bias and advocacy. The judges expect a QME to remain neutral. And also, these reports that appear overly favorable to one party, either the injured worker or the employer or the insurer, can actually raise suspicions and questions. And again, clarity in the treatment recommendations. Judges appreciate a clear treatment recommendation that they can actually follow. If a QME report lacks specific guidance on future medical care or rehabilitation, it also hinders the decision-making process. And then there comes a request for a supplemental report or potentially a deposition, or at the worst, they would throw out your report, determine it to be not substantial medical evidence, and request a new panel. And finally, we deal with legibility and formatting. While this isn't a medical but an administrative issue, the judges really do appreciate reports that are well organized, legible, and easy to follow. I strongly suggest that you're using Word, MS Word. I would use the MS Editor each and every time prior to you submitting your report. This will help catch things that you may just arbitrarily miss. Also, they talk about poorly formatted or illegible reports, and they can frustrate the review process as well. Finally, compliance with the regulations. The judges expect the QMEs to adhere to the California workers' compensation regs, and any deviations from these guidelines can be problematic and, again, eyebrow raising. So, in summary, the judges are closely scrutinizing these QME reports. And they want to ensure that it meets one, the legal standards, provides accurate assessments, and contributes to the fair outcomes in the workers' compensation cases. So I'm sure you're thinking the same thing, but okay, now what happens? We've submitted the two reports, and someone has reviewed them. What is the next course? Well, after we submit these reports to the DWC, at this point, I know that the submissions are required as part of the reappointment process. However, I don't have any more information than that as to what happens from there. But they do indicate that the DWC uses several strategies to monitor and to enforce compliance with this reappointment regulation. These include conducting audits, revoking certifications for noncompliance, and imposing penalties and fines. I guess we'll just have to find out when this does come to pass. So I'm sure you're questioning, like I was, all right, now that you have the reports and someone is reviewing them, what happens next? Well, we do know that the judges are looking for specific quality assurance issues here. Now you may ask, well, what can I do to be more proficient in the QME report writing so that I could provide the best QME report possible? Well, the DWC has that covered as well. They have actually posted a checklist to help the medical practitioners, such as the QMEs, AMEs, IMEs, and PTPs, write a consistent and accurate medical legal report. After all, the accurate report writing facilitates the prompt provision of appropriate benefits to the injured workers. That's what we're all looking for. Now, the topics in this checklist include a practical guidance on all of the aspects of preparing this medical legal report, as well as some definitions for the important terms and concepts that would be important to you. Now, here's a link that I provided for the California Medical Legal Quality Assurance Checklist. And it's a tool that helps physicians in developing their reports. It is just a template for medical legal reports, and it does help physicians as they develop their report. However, it is not a required format or a required template, but also it should not be relied on as legal evidence. This is just an outline for you to follow so that you can become more proficient in your report writing. In addition to the checklist for quality assurance that I had indicated on the last slide for you, I also encourage you to visit the DWC website, which is the DWC Medical Unit, to learn more about this checklist and other potential training options available to you. So, in conclusion, there you have it. I've been warning the followers of this blog for several months that something was coming. Now, our day of QME report writing reckoning is upon us as they prod us to become more proficient in our report writing efforts. Let's hope that these new requirements for reappointment as QMEs have a positive impact on our report writing as we continue to improve each day with each and every QME report. Doctors, I'm Dr. Chris Rapoff, and I wanted to thank you for taking the time to join me in this presentation. I hope you enjoyed it, and I hope you learned something. I encourage you to join next time as we explore other interesting topics as they relate to the California workers' compensation system. Until next time, thank you.